Hi, this is John Tompkins, the Defender in Indianapolis, answering another one of your questions. So today's question is, what does the attorney-client privilege cover and what does it mean? Good question, and here is the answer. Attorney-client privilege really is the client-attorney privilege. It belongs to the client. You do not have to pay any money for it to attach. The only requirement is that you are speaking to an attorney for the purpose of legal advice or representation. The privilege covers conversations. That means phone calls, texts, emails, things like that. Doesn't necessarily cover documents. Those might be covered by another privilege called work product privilege. It never extends to things that would obstruct justice. So future crimes are not covered. If you go in and tell your attorney you're planning to commit a crime tomorrow or later today, that is not covered under the privilege and would trigger a duty by the attorney to actually potentially report you. And you would count on probably being reported. But any past crime, and a conversation or communication, meaning, like I said, text, email, written letters, notes, those are all covered by the privilege. Do not turn evidence over to your attorney. That can be difficult. Evidence of a past crime cannot be destroyed or altered. If it's evidence for your defense, obviously, that could go either way, you can turn that over. But a gun, a knife, or something that was used in a crime, that's a whole different story. You should have a conversation that is covered by privilege if you have knowledge of that kind of evidence existing, but just walking in with it and in possession of it is a whole different ballgame. So the privilege would attach to a conversation you had with an attorney about how to deal with it, but it wouldn't necessarily apply to the object itself. And of course, no one can obstruct justice by destroying evidence, altering evidence, or changing it in any way. That's why you have to have the conversation to figure out how to deal with it appropriately. How about privilege being waived? Well, the biggest way privilege is waived is when clients talk to other people. So they talk to their wife, they talk to their kids, they talk to their neighbor, another lawyer. You would maintain the privilege. Okay, so that wouldn't waive the privilege. It would just create another privilege with the other attorney. Staff of your attorney's office, they are covered by the privilege for essential communications, passing messages, that kind of thing. But most staffs know to cut you off if you go too far. You don't want to talk about the entire crime. But you can have a brief conversation about what the topic of your meeting is that you're setting up for the attorney, just not much past that. And of course, emails that go to staff are also covered, but they shouldn't get into great detail. You don't want to put pressure on outside parties. Those are some nuts and bolts, some basics of the privilege. Again, it's mostly waived by clients waiving it and not realizing they're waiving it, just talking to other people or having a third person present in the room while you're having a privileged conversation. Even a spouse or sibling can waive that privilege if they're present. You need to have that separate conversation about whether you're waiving privilege before you have the privileged conversation in your attorney's office. The next thing to talk about is the attorney waiving the privilege. If an attorney is asked about a conversation that's privileged or other communication or asked to produce it, it's his obligation to contact you and say, will you waive the privilege so I can provide this to a third party, and here's what's going on. I will tell you, I always recommend to my clients that they not waive the privilege. And then my response to the request is, that's privileged information, I won't provide it. That party then has to go to court and try to get a court to order the attorney to turn over the material, and that requires a hearing where the judge in that court decides whether the privilege applies, or whether it's been waived, and whether the attorney does have to comply with the request. There's one other group. I said staff. I should have also mentioned their investigators. So an investigator or an expert, a ballistics expert or a DNA expert who's working on a case, most of their work is going to be privileged. Your conversations with them, however, are not privileged. So those have to go through your attorney to that expert or investigator, so there's a work product privilege between your attorney and that person on the defense team, and an attorney-client privilege between you and the attorney, protecting it on both routes. That's the nuts and bolts of the attorney-client privilege. A little bit about work product privilege. Be really careful. Don't just take this video as the know-all end-all. Take it as a good warning and a reason to have a further conversation with any attorney that you meet with about what the privilege means and how they apply it, so you know that you don't accidentally waive your privilege. And don't talk to the police, because clearly that waives the privilege too. Let your attorney handle all those kinds of negotiations and statements. Thank you very much for that question. A little bit of a longer answer, but it's a more complex issue. So again, make sure you talk to somebody in your specific case and use this video as a guideline for what questions you should ask them. Thanks very much. This is John Tompkins, the Defender in Indianapolis, Indiana.